And I made one more correction, on the criminal attempt first degree murder. And I think she sent that out to you. Were there any, corrections or anything from what, the party saw?
I did, Your Honor. I don't know if the state wants to go first.
I just have one issue that and it's always been something I haven't understood. So when the definitions of intentionally and transferred intent is in second degree murder, but not in first degree murder, and I don't understand why that is.
You said second.
Right, and so my position is that that language should be in the charge for murder one, because it is a criminal attempt murder one. It doesn't affect.
Criminal attempt second degree murder, or just second degree?
Well, so, yeah, so the transferred intent element is, so the criminal intent, by the time you get there, the court is saying, I've already defined.
I changed that.
Oh, did you?
I did.
Okay.
Because the criminal attempt, for serious bodily injury, I included, hold on, let me make sure she sent you the correct option.
And she may have.
We got a corrected one last night,
Okay, it's another.
or this
one.
morning, actually.
Now, let me make sure.
There you go.
That fixes my issue.
Okay. Did you have anything else?
No, ma'am. That's all.
Okay, all right.
I just note my objection to the change.
Okay. All right. Did you have any other changes, Ms. Fuchs?
Yes, Your Honor.
Okay.
On page 2, this is a unique situation in that at the last paragraph, or the last sentence of the paragraphs regarding first degree and criminal attempt first degree, it says that Latasha Daniels pleads not guilty to every count as encompassed, to every charge as encompassed. And we are not saying that she is not guilty of all of those offenses. We are saying that she is not guilty of first-degree murder, she is not guilty of second-degree murder, that this is at best a voluntary manslaughter. So I would like to take that language out, or at least change it to has pled guilty to the originally charged offense, or something along those
Okay,
lines.
which part are you talking about?
It's page 2, it's the last sentence.
Oh. The defendant pleads not guilty to each and every offense and breaks and not. You just want me to take that out completely on each one of them?
Yes.
Okay, that's fine. I can do that. Any objection from the state?
No, ma'am.
Okay, you have to take that out. No problem. Anything else?
Yes, Your Honor. Regarding the section on defendant testifying,
Let's see.
it's on,
I know they're not numbers. Let's see.
It's after direct and circumstantial evidence.
Okay, defendant testifying, yes.
Your Honor, I would just ask, it does say, like, subject to all of the rules that apply to judging the credibility of other witnesses. I would just ask that it be made clear that, just like with other witnesses, the law presumes that a testifying witness is telling the truth, and to be given a full and fair consideration. I mean, really, that first paragraph of credibility of the witness, minus all of the factors that they need to look at, I would suggest adding into that defendant testifying so that it's clear that the same rules apply for Ms. Daniels as applied to all of the other witnesses.
So what are you suggesting to be added? What language are you suggesting?
The, if you go to, so it's kind of cross-referencing, if you go to the credibility of the witness,
Okay, I'm
that's
here.
25 pages in, that
Yes.
first paragraph that says, if there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can.
Mhm.
For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important their testimony was. You do not have to accept that basically that whole first paragraph for the credibility of the witnesses. But particularly the fact that the law presumes that witnesses are testifying truthfully if the jury can find them. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. Just because it's one says witnesses and one says defendants, so I want to make clear that the defendant is a witness that also has the presumption that they are telling the truth.
Okay, so the language specifically that you want to add is, I want to make sure I have that clear.
If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth.
And then keep her credibility is determined by the same rules of credibility of other witnesses determined. So you just want to add that one sentence.
Yes.
All right, what's the state's position on that?
It's the pattern instruction. It's clear to me. I don't see a reason to change with the instructions from the AOC on that.
You said what? Well, it's kind of duplicitous because I'm telling them that she's determined by the same rule of credibility of other witnesses, and then this is a section on credibility of witnesses, and those are the
then
rules.
what we could do in the alternative would be in the credibility of a witness section, include a phrase that, the credibility of the witnesses, the law presumes that every witness, including the defendant in this case, That would achieve the same goal. I just want to make clear that the law also presumes that Ms. Daniels is telling the truth, just as it does with all of the other witnesses.
What's the state's position on that?
Again, I don't know how that's not clear. She's a witness, and it specifically just tells the jury that they're to judge her by the same credibility as every other witness. Adding anything just like almost emphasizes to the jury that you should believe the defendant more than any other witness in the state's mind. That's not appropriate. So the charge is clear, and it's the pattern charge, and I'm opposed to any change in that.
Your Honor, I disagree. I think that when we have referred to witnesses throughout this entire trial, and we have referred to the defendant throughout the entire trial, those sound like two separate parties. And so if the jury's not clear that even though she is the defendant, she also, under the law and under the instructions, is a witness that should be treated the same way as the other witnesses, then that's impairing her right to have a fair consideration by the jury.
Or can we just say that the defendant is a witness and without all this?
I mean, I think if adding
Defendant
that.
having testified, defendant as a witness, having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will have to give the defendant's testimony, in this case, such weight as you may think it is entitled.
That's, Your Honor, I guess my issue with that is that the language in those two sections are very different. The language between the general credibility of a witness and the assessing the defendant testimony is very different language. Give it whatever weight you think it deserves is very different than the law presumes that these people are telling the truth.
I'll come back to that one.
Your Honor, there also, we had talked a little bit a couple months ago about the Supreme Court denial of certiorari from Sotomayor regarding Tennessee's instructions on second-degree murder and voluntary manslaughter. Justice Sotomayor took the position that Tennessee's instructions for sequential considerations in regards to second-degree murder and voluntary manslaughter are unconstitutional. And that is because voluntary manslaughter actually has an extra element that is not in second-degree murder. And we should be moving down and reducing elements rather than adding them. As far as the order of consideration being sequential, I would ask that the court instruct the jury to consider second-degree murder and voluntary manslaughter together rather than sequentially, because voluntary manslaughter has that separate element that makes it different than second-degree murder. But it's an additional element, an additional finding that the jury would not be able to get to if they did not move past second degree. So I would just ask on the sequential consideration to consider those two together.
What's the state's position?
That opinion did not change the law in Tennessee. It was one justice's opinion who was in the minority. Until the law changes, I think it's clear that the way we charge this in Tennessee is first degree, second degree, and then voluntary manslaughter.
I mean, I get your point. I mean, it makes sense, but, you know, at this time, the law is what the law is. But I definitely get it. You know, it's an additional element, but the law, at this point, I have to follow what the law is currently. And so I note your objection because I get it's an additional element, and usually when it's a lesser included, it's one that goes, you know, it's a less element, but in this case, there is an additional element, and so it makes sense to me, but, you know, I have to follow what the law is currently, which they go in that order, so I'm gonna have to overrule their objection at this time.
Thank you, Your Honor. And then I would just note on page 39, there was a somewhat duplicative,
Which, one?
it was no outside communications, but on page 2, there's no independent research or discussions. So I just wanted to note the duplication.
Okay.
And it's not an exact duplication, but it's very, very similar.
Okay. You have any objection to that being removed?
No, ma'am.
All right. All right, give me a second on that other one. I have to step off and do a little research.
Thank you, Your Honor.
All right. on the defendant, testifying, I'm gonna leave the instruction the same, because I don't wanna, I mean, the language, I feel like it's duplicitous to put that in there twice, because the defendant testifies she's treated as a witness, and the instructions say her credibility is determined by the same rules that the credibility of other witnesses is determined. And so, the credibility of witnesses, there's a section titled that with everything that she's supposed to be given the same weight as everyone else. So I'm gonna deny that request at this time.
And Your Honor will not consider even adding the language that you had suggested about saying when she testifies, she's considered a witness.
I'm gonna leave it the same. All right, were there any other corrections? I gave you each a copy. If y'all wanna take a moment to look at that to make sure there's not anything else before we print them off.
If we can have a minute, please.
Okay, sure.
On intentionality, the pattern instruction,
Which one?
um,
Which section?
what was added to the criminal attempt?
That's a pattern instruction for criminal attempt. First degree murder with serious bodily injury. That's a pattern instruction.
Is it the pattern instruction for regular first degree?
There is two separate instructions. It's one for first degree murder, and then there's a separate instruction for criminal attempt, first degree murder with serious bodily injury.
Yes.
There's a separate instruction.
I guess my issue is that by adding, we're adding language to the criminal attempt first degree murder that's not in the pattern instruction. This says the essential elements necessary to constitute first degree murder are. And then it goes into that paragraph that is not part of the pattern instruction.
I think that's what's, hold on one moment. A.
That's telling the jury this is first degree murder, but it's different than the pattern given for first degree murder.
It's an attempt, so it said the defendant unlawfully killed the alleged victim, that the defendant acted intentionally. Oh, we forgot, and the killing was premeditated. One, let me make sure she had that. That's the instruction. That the essential elements necessary to constitute first-degree murder are the defendant unlawfully kills the alleged victim. That's under the first-degree murder. In count one, the defendant acted intentionally. That's there, and that the killing was premeditated.
Yes. But what I'm looking at on the instructions that you're giving for first-degree murder says that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim.
Right. And so, what's the additional language is not there?
It just is, I think it will be confusing to have two different definitions of first-degree murder in the same.
The difference is that because it's criminal attempt first-degree murder, there's a reference to Millen, State v. Millen, and the fact that you can have the intent to kill another person. And so I think that's why the additional language is there in criminal attempt first-degree murder versus first-degree murder, because of the fact that you can get criminal attempt murder by just having the intent to kill someone, not necessarily the person who is alleged in the indictment. So I think that's what the distinction is.
Okay. I just was concerned by the fact that we have two different definitions of first-degree murder.
I think it's just different because of that. In the pattern instructions, that language is there, and I think it's because of that law, and that's bracketed language. What I included, so it's not always included, but I included that because there's an issue about intent. You know, whether she had the intent to kill Miss Perry. So it's bracketed language. It's not necessarily required to be included in there, but I included in there because of the proof that came out.
Thank you.
All right, you're welcome.
Would Your Honor consider, given the issues about the voluntary manslaughter and second-degree murder, would you consider a sentence at the end of the first paragraph under second degree indicating with second degree, the jury should should consider whether a heat of passion was present at the time of the alleged killing? Putting that they should be considering that at that point in time as a way to address that issue?
This is a pattern instruction. So do you have any case law to say that I can't do that?
Your Honor you are allowed to change instructions. We're allowed to draft instructions and put them forward for the court's approval. They just have to comport with the law. And as long as they comport with the law, the court is allowed discretion within the jury instructions.
Okay, what is it you're asking for again?
So because of this issue, that is a very new issue brought up by that denial of writ, with Sotomayor basically telling Tennessee Supreme Court, you need to fix this. It is currently unconstitutional. We have been told by the United States Supreme Court that our jury instruction framework is unconstitutional. This is a way to address that so that Ms. Daniels gets a fair consideration by this court when they're comparing second-degree murder and voluntary manslaughter. And especially in this kind of case when we're saying this is a voluntary manslaughter, that for them to not be allowed to move to that section because of the way that our jury instructions are ordered completely denies her right to a fair trial. So if we just added a sentence to say, you know, this is the distinction between voluntary manslaughter and second-degree murder, is that voluntary manslaughter requires the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Even if you just said, you know, like the jury should consider whether a heat of passion was present during this alleged shooting. Here.
I think it's already saying that though, because I mean, it's showing you a distinction between both, and so.
Yes, but it's not telling them to consider voluntary manslaughter yet.
What's the state's position?
The law in Tennessee is that you charge first-degree murder, second-degree murder, and voluntary manslaughter. Until that changes, I think that's what the court should do.
And I get your point, Ms. Speaks. I do, I understand what you're saying. It's just, this is the law, and I have to follow what the law is. But I get your point.
And I'm not asking you to change the law. I'm asking you to provide some clarification to the jurors regarding that. And that's what these instructions are supposed to do. They're supposed to help guide them through this process. And when we have a situation to where second-degree murder and voluntary manslaughter are sequential, they don't move to that heat of passion according to the jury instructions. They don't move to that heat of passion until they completely acquit of second-degree murder. Then if you don't tell them you need to take this into consideration here before you, I mean, like if in the decision on whether or not to acquit on second degree and move down to voluntary manslaughter, then they don't get to the point that they are able to consider that as an element. That's asking them to do the cafeteria style that we're not allowed to do.
I mean, these are the pattern instructions adopted by the Supreme Court, and at this point, I'm gonna deny the request. I get it, but I'm gonna deny the request because that, I mean, these are what they have set out, you know, what we're to use. So at this point, I'm gonna deny the request.
Given the fact that the jury instruction requests specifically are supposed to be in writing, would the court give me a moment just to draft a pleading so that I can file it, to have it in writing to make the record?
Yes.
Thank you. No, Your Honor, I will include in that written request my additional request for the language regarding the defendant and witness credibility.
Okay. But other than that, there's no, those objections, was there anything else?
Oh, the issue, did you take out the language of the not pleading not guilty? to all
Yes, I
encompassing?
took that out. Did the state have any corrections?
Before the section on defendant testifying?
What's the state's position?
I thought that's generally given when the defendant doesn't testify. So I'm not sure what the purpose of it is if the defendant testifies.
What's the point?
Your Honor, it's to clarify the burden of proof. It is to make clear, and I'm checking the burden of proof section now. But being clear that that does not place a burden of proof on the defendant.
Let's see. The state has the burden of proving the defendant, the guilt of the defendant beyond a reasonable doubt, and this burden never shifts or remains from the state throughout the trial of the case. The defendant is not required to prove her innocence. So I think that's, yeah. She doesn't have to prove anything.
crime charged and plea.
Oh, okay. Let's change the crime charge.
Yes. Or if we wanted to leave the and plea, we could add a second, like a final sentence that says the defendant pleads not guilty to the offenses as charged.
What's the state's position on
Either one of those is.
I'd prefer the second.
that? The defendant,
Pleads not guilty to the offenses as charged in the indictment.
defendant pleads not guilty to the as charged, is what if it's charged? in
To the
indictment?
offenses as charged in the indictment.
Okay.
And just semantically, I'd probably rather offenses charged rather than crime charged.
What do you mean on the heading, offenses charged?
Yes.
What's the state's position?
Yeah, I can give it an answer. I mean, it's a crime. It's charged as a crime, and that's what this charge says. So I don't know why we would change that.
Offenses charged, crime, same thing. Offenses charged. So do you wanna keep the language about the plea?
If we could just add that final sentence, the defendant pleads not guilty to the offenses as charged in the indictment.
Okay, but the heading, you want?
If, yes, then we can
offenses
leave
charged.
it offenses charged and plea. And then it outlines the offenses and then gives the plea.
Okay. All right, so were there any other changes besides that? Before we make the copies? I noted your objection.
Thank you, Your Honor. I do have that, written request on the way.
Okay.
thought of when you walked out was adding page numbers.
Okay. Page. What's your position, Mr. Lincoln?
I don't have a position on page number.
Okay.
We don't, if you've already started printing.
We haven't printed it yet. Okay.
just kind of as a logistics matter, are we planning to charge lunch close? It's 11:15 now.
I know, and it's looking like it's gonna be that way, but I was hoping that we could get it done before lunch, but it's probably not going to happen, but I was hoping.
The court could limit the time for both.
I need to do that. But, okay. All right.
Thanks for joining us here on 24 Plus. I'm Leah Williams with Chief Meteorologist Trevor Burchett. We were talking about that roller coaster of weather. It's going to be crazy. Everybody's going to be sick.
I know. My allergies already not happy about it.
Man.
We're in the 70s today, but you can kind of see the weather starting to change. We have some clouds rolling in and even some sprinkles in parts of the mid-south, but the colder weather is not coming yet. It is going to be warm and cloudy today, though. Maybe a little mist over downtown right now, but most of the mid-south is dry. Current temperature 70 degrees. Wind's a little breezy right now out of the southwest at around 10 to 15 miles an hour. Now, there are some showers up in northwest Tennessee right now, but again, most of us are dry. This is a possibility through the rest of the afternoon. There could be a couple of quick showers, but I think for most of us, we turn out pretty dry today. Temperatures get up to the mid-70s, maybe a peak or two of sunshine, but I do expect in general the clouds to hang around. Again, there could be some showers through maybe 5 or 6 p.m., but I don't think it's a big deal for most of us. What is going to be a big deal, though, is this blast of cold air that is coming this weekend. Our big cold front comes in Saturday night, and that is going to bring us some much colder weather Sunday, likely the first freeze of the season Sunday night, with low temperatures in the 20s and 30s. So a big time change on the way. We're going to talk about how low those temperatures will be in your neighborhood and what you can do to prepare for the first freeze of the season. So when I see you back here in just a couple of minutes.
We start with a live look at our nation's capital, where it's day 38 of the government shutdown, making it the longest in U.S. history. And there's no clear end in sight right now. Plus, chaos could erupt at 40 major airports. You can see the map here. That's all of the airports impacted by the FAA's new order to cut back on the number of flights each day. The airlines say passengers with canceled flights will be notified, but how this all plays out appears very much still up in the air. ABC's Nicole D'Antonio has details.
This morning, flight reductions at 40 major airports are beginning to take effect. The FAA has ordered airlines to reduce flights at so-called high-impact airports by 4% this morning. That will gradually increase to 10% of flights by next Friday. Airlines not following the rules will be hit with a $75,000 fine per flight over the limit.
This is going to be huge. So on a given day in the U.S., there might be 100 to 200 flights canceled. This is going to be 4,000.
The FAA says the air traffic reduction is needed for safety because of the shortage of air traffic controllers and TSA agents during the government shutdown. They're being forced to work without pay, and many are calling out sick. American Airlines beginning today will cancel about 220 of its 6,000 daily departures. Delta is canceling 170 per day, and United fewer than 200 per day through Sunday. Multiple airlines are offering refunds and free changes for impacted flights. Another major issue during the shutdown is government food assistance. A federal judge yesterday ordered the Trump administration to provide full SNAP benefits to states by today. The administration had previously said it would use emergency funds to only partially fund the benefits. The administration is appealing the judge's order, once again leaving nearly 40 million people who rely on SNAP benefits in limbo. Nicole D'Antonio, ABC News, Washington.
This morning, flight reductions at 40 major airports, including here at Memphis International, are beginning to take effect. The FAA has ordered to cut back on flights here in Memphis. Now, this is a look right now at the flights at Memphis International. Nothing too crazy, a few cancellations and a few delays, but if you have a connecting flight, that could be impacted. So just make sure to keep up with your airlines. Now, we are going to go ahead to the trial that we've been covering all week for Latasha Daniels.
jurors are entering the courtroom, Your Honor.
You may be seated. Good morning. Good morning. All right, we're ready to get back to work. It's now time for me to instruct you on the law. If you could pass me a copy of the instructions. Do we have a copy? State of Tennessee versus Latasha Daniels, indictment number 2501253. Members of the evidence in this case has been completed and the arguments are soon to follow. Now it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experience in life. Offenses charged and plea. The defendant, Latasha Daniels, is charged in count 1 of the indictment with the crime of murder first degree. The offense necessarily includes the lesser offenses of murder second degree, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The defendant, Latasha Daniels, is charged in count 2 of the indictment with the crime of criminal attempt murder first degree. The offense necessarily includes the lesser offenses of criminal attempt murder second degree, criminal attempt voluntary manslaughter, and reckless endangerment. The defendant, Latasha Daniels, is charged in count 3 of the indictment with the crime of employing a firearm during a felony. The offense necessarily includes the lesser offense of possessing a firearm during a felony. The defendant pleads not guilty to the offenses as charged in the indictment. The law makes it the duty of the court to give in charge to the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them on the trial and under the law given them by the court, render their verdict with absolute impartiality. No independent research or discussion. You as jurors must decide this case based solely on the evidence presented here within the 4 walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you, this case is interesting and noteworthy. I know that many of you use cell phones, the internet, and other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case. This includes your family and friends. During your deliberations, You must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. Notes. Members of the jury, you have been allowed to take notes in this case. The court charges you that these notes are for your individual use only, and you should not use said notes directly or indirectly to persuade other jurors as to the accuracy of said notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by the maker of said notes as an aid to his or her individual memory. Indictment. The indictment in this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements and arguments of counsel. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The court will now explain to you the law applicable to count 1 of this indictment, murder first degree. First degree premeditated killing. Any person who commits the offense of first degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodus Perry, and 2. That the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3. That the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the crime after the passion has subsided. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodus Perry, and 2. That the defendant acted knowingly. Knowingly means that a person acts with an awareness that her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause result the death of a person, then the killing of another, even if not the intended victim, would be second-degree murder. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in a rational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodus Perry, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. Intentionally and knowingly have previously been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, Brodus Perry, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and a degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have previously been defined in these instructions. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, Brodus Perry, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have previously been defined in these instructions. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. The court will now explain to you the law applicable to count 2, criminal attempt first-degree murder charged in this indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder where the victim suffers serious bodily injury is guilty of a crime. For you to find a person guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the offense of first-degree murder against alleged victim Tabitha Perry, and 2B, that the defendant did some act intending to cause an essential element of first-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part, and 3, that the alleged victim Tabitha Perry suffered serious bodily injury. New and known means that a person acts knowingly with respect to the conduct or to circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute first-degree murder are: 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that she did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused is sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a bodily function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Criminal attempt, second-degree murder. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2b, that the defendant did some act intended to cause an essential element of second-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intent has previously been defined in these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The essential elements necessary to constitute second-degree murder have previously been defined in these instructions. Criminal attempt, voluntary manslaughter. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of voluntary manslaughter, and 2b, that the defendant did some act intended to cause an essential element of voluntary manslaughter to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intent have previously been defined in these instructions. The essential elements necessary to constitute voluntary manslaughter have previously been defined in these instructions. Reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in a zone of danger. The zone of danger is that area in which reasonable probability exists that the defendant's conduct will place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Recklessly, intentionally, and knowingly have previously been defined in these instructions. The court will now explain to you the law applicable to count 3, employing a firearm during a felony charged in this indictment. Employing a firearm during the commission of a dangerous offense. Any person who employs a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant employed a firearm, and 2, that the employment was during the commission of or attempt to commit criminal attempt first-degree murder against alleged victim Tabitha Perry, and that the defendant acted intentionally, knowingly, or recklessly. Employ means make use of. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive or any device readily convertible to that use. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and justifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that a defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Unlawful possession of a firearm with intent to go armed during the commission of or attempt to commit a dangerous offense. Any person who possesses a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm, and 2, that the possession was with the intent to go armed during the commission of or attempt to commit criminal attempt first-degree murder, and 3, that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly, intent, and firearm have previously been defined in these instructions. Possession may be actual or constructive. A person who knowingly had direct physical control over an object at a given time is then in actual possession of it. A person who, although not in actual possession, knowingly had both the power and intention at any given time to exercise dominion and control over an object is then in constructive possession of it. Possession may also be sole or joint. If a person has actual or constructive possession of the thing, possession is sole. If 2 or more persons have actual or constructive possession of the thing, then possession is joint. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that the defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Presumption of innocence. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and that this presumption stands as a witness for her until it is rebutted and overturned by competent and credible proof. It is therefore incumbent upon the state, before you can convict a defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and state of Tennessee before the finding of this indictment, and that the defendant at the bar committed the crime in such manner that would make her guilty under the law heretofore defined and explained to you. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof general. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Burden of proof, elements and date of offense. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Impeachment of witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with the witness's evidence on the stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Excuse me. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it plainly appears that some witness has testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Credibility of witnesses. You should consider all the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are, based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors. 1. How the witness looked, acted, and whether the witness appeared to be telling the truth when he or she testified. 2. Whether the witness was in a position to know about the manner to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard. 3. Whether the witness's statements were consistent and how believable the statements were. 4. Whether the witness had a motive to testify truthfully or to testify untruthfully. And 5. Any proof presented of the witness's reputation for telling the truth. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it plainly appears that the witness has willfully testified falsely. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown and all the evidence in the case tending to corroborate or contradict him or her. Expert witness. During the trial, you heard the expert testimony of Erica Curry, a forensic pathologist. Dr. Amanda R. Bidding, during the trial, you heard the expert testimony of Erica Curry, in forensic pathology, Dr. Amanda R. Bidding, PhD in forensic and clinical psychology, and Special Agent Brock Sane in firearms identification. All were who were described to us as experts in their fields. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision would depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Identification. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which she is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Latasha Daniels, committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether she has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. Evidence, direct and circumstantial. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, Direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both circumstantial, both direct and circumstantial, and give it whatever way you believe it deserves. Defendant testifying. The defendant having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will give to the defendant's testimony in this case such weight as you may think it is entitled. Unanimous verdict. The verdict must present the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliver with a view to reaching an agreement. If you can, do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Unanimous means agreeing in opinion, being in complete accord, agreement of all jurors in holding one and the same opinion. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or you have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You should not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that account, you should return a verdict of not guilty and proceed to the next count. The charged offense in count 1 of this indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of first-degree murder as charged in count 1 in indictment 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of lesser included offense beyond a reasonable doubt, if you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 1 in indictment number 2501253. Insert instead blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 1 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 2 of this indictment is criminal attempt first-degree murder. The lesser included offenses in order of consideration from greatest to least are criminal attempt second-degree murder, criminal attempt voluntary manslaughter, reckless endangerment. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of criminal attempt first-degree murder as charged in count 2 in indictment number 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt to this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least, as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 2 in indictment number 2501253. Insert in said blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 3 of this indictment is employing a firearm during a felony. The lesser included offense is possession of a firearm during a felony. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of employment of a firearm during a felony as charged in count 3 in indictment number 2501253. If you find the defendant guilty of this charge, you must identify the felony, either criminal attempt first-degree murder checkbox, criminal attempt second-degree murder, criminal attempt voluntary manslaughter checkbox. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of the lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 3 in indictment number 2501253. Insert in said blank the lesser included offense. If you find the defendant guilty of the lesser included offense, you must identify the felony, either criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 3, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. Selecting foreperson. When you retire to the jury room, you will first select one of your members as foreperson, who will preside over your deliberations. When you have reached a verdict, you return with it to this courtroom, and your foreperson will announce the appropriate verdict form to the court. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demands. Signed, Judge Jennifer Fitzgerald, Criminal Court, Division 2. All right, so I have given you the law in this case. We're going to recess for lunch, and when we come back, you'll hear the attorney's closing arguments. And I have to remind you again, we're still not ready to discuss the case, okay? So I'm gonna excuse you for lunch. We'll come back, I guess at 1:45. I'm not sure if lunch too yet. We'll come back at 1:45. But I'm gonna excuse you for lunch, and we're still not ready to discuss the case.
Let's get your paperwork in your chairs, please.
Do you want me to have your copy stamped or do you?
All right, we can come back at 1:45.